Today, I'm standing outside the Supreme Court of Canada to talk about Bill C-46, the Trudeau Government's impaired driving legislation. If this bill passes without amendment, you'll see a lot more of this building in news stories about charter rights violations, legal wrangling, and court delays. Bill C-46 changes the law around roadside testing for alcohol. Under these new random alcohol testing provisions, police would be able to pull you over at any time without reasonable suspicion of impairment to demand that you take a breathalyzer test. Doesn't sound fair, does it? The vast majority of legal experts at our Senate Legal Committee don't think so either. In fact, in my 5 years on that committee, I've never heard legislation so roundly condemned as unconstitutional. Experienced lawyers testified that this random alcohol testing provision would bring a decade of charter litigation. Racial profiling is also a major concern. One witness even said that if random alcohol testing measures passed, it would be Christmas for defense lawyers. That has dire practical consequences. A recent game-changing Supreme Court decision placed strict time limits on court delays. This means that serious criminal charges, including murder, sexual assault, and child assault, are now being thrown out of court because of court delays. The charter rights infringement of random alcohol testing will exacerbate this crisis. That's why I recently proposed and passed with majority support of the Senate Legal Committee an amendment to remove random alcohol testing from Bill C-46. I'm tough on crime. That's why I don't want murderers and rapists to go free because of court delays caused by unconstitutional legislation like this, while law-abiding Canadians are potentially treated like criminals by the state. The Justice Minister called our committee's decision to remove these provisions from the bill irresponsible. I think it's irresponsible for this Justice Minister to be acutely aware of Canada's court delay crisis and to fail to take the most basic actions, like appointing more judges, to address it. As senators, our role is always to provide sober second thought on legislation. That is what we've done by voting to remove this unconstitutional measure from Bill C-46. We're protecting Canadians' rights and their safety.